All right, with that, what we're going to do is kind of wrap up. I'm going to wrap up with the other documents that actually go with the trust. And in particular, what I'm getting at is you're going to get an advanced healthcare directive. This is your healthcare power of attorney, and it includes the living will. A lot of people are confused what a living will is. A living will is really the documentation or the language that pulls the plug. In other words, I don't want to be supported on life support, so pull the plug. That's what a living will is all about. In the old days, prior to 1992, a living will was a separate document from your healthcare power of attorney. But after 1992, both the living will and the healthcare power of attorney have been put into one document, which is why we now call it an advanced healthcare directive. Now, advanced healthcare directives are, well, they're not very changeable, meaning that there's not a lot of changes that happen to these documents. But the number 4 bullet point down there, the HIPAA compliance, you want to make sure your advanced healthcare directives have the HIPAA compliance. HIPAA is the federal law regarding the privacy of your medical records, and you have to have a little paragraph in every advanced healthcare directive with this clause in there so that the hospitals and the doctors that you're working with and the nurses feel comfortable in talking to your agent about your condition. Because if they're not HIPAA compliant, they may refuse to talk to your family and specifically the agent that you've nominated to hear and make decisions for you if you can't, and we don't want that to happen. So you need that HIPAA language in these documents. The next document you're going to get is probably the most important document that you could have outside of the trust itself. It's your financial power of attorney. Now, banks are very picky about honoring these financial power of attorneys. They're very skeptical of them. My biggest advice I can give you is if you're starting to take care of mom and dad and you're needing to, use the financial power of attorney to manage some of their assets, I would go into the banks that your mom and dad frequent, get to know the people, have them recognize you, because when you really need to go in and need their help to manage monies, it's going to help if they recognize who you are and the fact that you are a son or a daughter that is walking in to manage things on behalf of the folks. Typically, if you're a guy, you're a son, you're walking in there at 3 o'clock on a Friday afternoon at Chase and you're, saying, I got to get into my mom's account, I got to pay a bill, they're not going to let you do it. So, get to know who these people are. It goes a long ways. Yes, the financial power of attorney document has all the legalese giving you the right to manage things on behalf of your parents. Now, one of the most important part is our elder law part of our financial power of attorneys. That's the Medi-Cal language I'm mentioning down there. We're going to do another presentation at some point regarding Medi-Cal. What I want to mention right now is California is the only state in the nation that allows you to shelter all your assets, your pension, retirement plans, your money in the bank, and your real estate prior to qualifying for Medi-Cal to pay for long-term care. We're running under 1980 federal Medicaid rules that allows us to do this, and we're the only state left in the nation that does allow us to shelter everything we have. If you go to any other state to deal with long-term care, there is no movement of any of your monies, real estate, or pension retirement plans 5 years prior to going into the nursing home. Otherwise, you're ineligible. So in other words, you really can't do it in another state without a lot of hassles, or I should say spend down the money unnecessarily. Again, in California, we can save it. It starts with the language, which is why I've been emphasizing this. And so our Medi-Cal language appears both in our financial power of attorneys, but it also appears in the trust. So if you're a person that's getting only a will, you will get the financial power of attorney with that will, along with the healthcare power of attorney, and you will also have the Medi-Cal language just in case long-term care becomes a big issue. Now, you're also going to get a nomination of conservatorship. The purpose for having a healthcare power of attorney and a financial power of attorney is not to have to go into court and set up a conservatorship. However, sometimes things go south on us, right? And sometimes it's usually because our parents will not let us take care of themselves. They don't recognize that they need the help. If this becomes a problem in your family and you now have a situation where mom and dad are actually really hurting themselves by not allowing you to help them, you may need to go in and get a conservatorship because they're not letting you operate under the health care or the financial power of attorney. So the way we cut through the bureaucracy of going into court on this matter is we put a clause in your healthcare power of attorney and in your financial power of attorney where you're already nominating who your conservator is going to be. When I file paperwork in court regarding a conservatorship, that paperwork asked to attach your health care and your financial power of attorney. The reason for that is the judge is going to look at this clause and determine who you picked when you were competent, and that has a lot of weight on who the judge is going to approve as the conservator of yourself and your estate. So this is a very important clause, and that's why I emphasized it today on our presentation. Now, you're also going to get what we call a letter of instruction. You know, the trust lays out who's going to get what and how much, but it a lot of times operates in percentages, but it doesn't really go into who's going to get the clock, who's going to get the car in the garage, who's going to get that picture on the wall, so to speak. Well, this is what the letter of instruction does. The letter of instruction is attached to your trust, and in your own handwriting at your own kitchen table, you can write down who's going to get personal effects. And you're allowed to scratch it out and change it. All you have to do is sign and date it. It's in your handwriting. It's a part of the trust, and therefore you can make personal choices on who gets personal items. Now, a lot of times, if I can stereotype how this works, us guys don't really care one way or another, and ladies love to fill it out. So my bottom line here is this is a great tool to use. You can do it yourself at your own kitchen table, at your own leisure. It will be part of your estate plan, and yet you're not coming back to me to amend a trust on who's going to get a clock. That would be kind of silly, right? So this is where you do that. Now, this letter of instruction goes beyond that. You can write down burial instructions and who should be notified if anything happens to you. You know, if you're going to have a safe at home, you want to know how to get into it, this is where you put that information down too. Finally, you're going to get a pour-over will with your trust. Everybody asks me, why do I have to have a will with the trust? Well, remember, the trust is only as good as what we're actually titling into it. By changing your house title from joint tenancy to the living trust means we're avoiding the probate. But remember, there were certain items we're not putting under the name of the trust. Your checking account, your cars, and your personal stuff. So the pour-over will is designed to grab those leftover items and pour them into the trust as if they were part of it. So if you think about it, the pour-over will acts as a catch basin. It grabs the leftover items we're not titling into the trust and pours them into the trust, and unless you pick a beneficiary. So for example, IRAs, life insurances, your pension retirement plans, and annuities, they're not going to go into the trust through a pour-over will because you already have designated beneficiaries. They go directly to those designated beneficiaries. So lastly, if you're husband and wife, I'm going to give you a community property agreement, mostly just because we're in a community property state. Now, I purposely dummied the language down on this. I don't get into what is separate property, what's community property. I found that lawyers like to take that type of documentation and spin it into something that it's really not. And so if the language isn't in there, they can't take the language and spin it into something that it's not. So what I'm getting at is this community property agreement really only deals with collectible type items, you know, like, I don't know, the baseball card collection, the Yadro collection. You don't have a title to those types of assets, but we're going to call it a community asset. And in doing so, it allows a stepped up tax basis to occur on that collectible item at death, which means the family can sell it without a capital gain hit. So most people don't have a use for the community property agreement, but it is a necessary document that goes with the package itself.